Good afternoon, and welcome to a webinar on navigating CBP and prior notice of FDA's imported products, hosted by EAS Consulting Group and presented by EAS independent consultants, William Scopa and Angel Suarez. EAS specializes in FDA regulatory matters with a prime focus of assisting domestic and foreign food, pharmaceutical, dietary supplement, medical device, tobacco, and cosmetics firms comply with applicable laws and regulations. Staffed with former FDA and compliance and inspection officials and executives, and is assisted by an extensive network of consultants with many years of FDA and industry experience. Today's presenters are Bill Scopa and Angel Suarez. Spent his career at Customs and Border Protection at both ports of entry and headquarters, where he processed import and export clearance of cargo and passengers, and the development of policies and procedures addressing such areas as intellectual property rights, anti-dumping and countervailing duties, and revenue collections. His last position with CBP was included liaison to other government agencies to develop CBP import processing of imports for EPA, FDA, and DEA. Angel Suarez is a former supervisor consumer safety officer with FDA. He had responsibility of import enforcement in areas of seafood and low-acid canned food, as well as foreign inspections, warning letters, detentions, import alerts, import bulletins, and sample collections. Author of numerous publications, including portions of the National Shellfish Sanitation Program's Shellfish Equipment Construction Guide. In addition, he has developed courses including FDA Certified Better Process Control School and sampling of abnormal food medical containers, and FDA Shellfish Officer Standardization course. As a reminder, during the webinar, you may ask any questions by typing them into the questions box. I will say thank you for joining EAS, and I'll turn the presentation over to Bill and Angel.
Okay, thank you, Amy. This is Bill. Hi, everybody. Today I'm going to go over a few things about CBP. First of all, I'm going to talk about the structure of CBP, its organization, how CBP does enforcement, its focus, how we coordinate with other government agencies, particularly with FDA, and then I'll go over some ways in how to importers can comply with CBP's regulations. Oh, slide isn't going yet. Sorry. There we go. All right, that's CBP's org chart. As you can see, we're a pretty big, we're a big agency. A lot of ancillary offices. The major ones, though, are the dark blue in the bottom, are the 4 operational offices. There's Border Patrol, of course, which operates between ports of entry. We have, since 9/11, we have the air and marine operations. They actually have aircraft and boats that are out there on the seas. There's the Office of Field Operations, which monitors our field operations, our people, our CBP officers, and the import specialists that do all the work as far as inspections and classifications and value. Those are the import specialists. Then we have the Office of Trade, which I spent most of my career in headquarters, which creates the policy regarding how the import specialists do enforcement in the field. One other note I'd like to note for the industry is on the upper left, right beside Deputy Commissioner, you see Trade Relations. That's an office that's a liaison with the trade. They run our biannual trade symposiums that we hold. It's an opportunity for the trade to actually listen to CBP leadership and other management, go off and break groups with them, talk to them one-on-one about issues. So if you ever have, if you're not satisfied with the way CBP might be treating you or something, that you can outreach to that office of Trade Relations. All right, so let's move into how CBP operations. These are the items, the ways that CBP enforces. Of course, we perform exams and we do all that other stuff, lab tests, audits. But recently, we've coined this phrase called one government at the border. And part of that is that CTAP that I have up there. We actually CBP sits with about 15 other government agencies that actually work and coordinate with each other, have the same access to all systems, and they do targeting and analysis. We have Centers of Excellence, which came about 3 or 4 years ago, which coordinated all the port activities into these 10 Centers of Excellence, so there's more uniform application of CBP laws and regulations. The other thing we do is, you'd be surprised how often we get information from other industry members and trade allegations from the industry that lead to big seizures and things like that. And of course, once we do find some violations, those are the actions we can take. And that bottom one, there's actually, if you didn't know it, there's actually 47 other government agencies that have all or some access to all the import and export data that comes in and out of the country. And I'll talk about ACE a little, how they have access to that as we go along. The automated commercial environment, the new system where all the entries come in. CBP, there's over, last I saw, the figure was over 2 million transactions a month that the CBP processes. I think that's even more now. So, of course, you have to focus your priorities. So CBP spends a lot of time. Our Office of Trade actually has divisions that deal with these specific issues, agriculture and quota, which, many of the FDA importers, there's a cross relationship there a lot of times with products. Anti-dumping countervailing duty, which is where we assess, Department of Commerce assesses high rates of dumping duties, anti-dumping duties they call them, and CBP enforces that. Import safety, that's a big topic too. I'll get into that a little about how we enforce that and what are the issues there with import safety. And of course, there's all these other issues you hear in the news, intellectual property rights and trade agreements. That's a big thing. There's actually about 14 actual trade agreements, things like NAFTA, CAFTA, Singapore Trade Agreement. But not only that, there's other programs like General Size Systems of Preferences, special legislation, and recently in the news, all the 301 activities where the administration is placing duties on specific products from countries or just countries, blanket countries. So, there's a lot there that CBP does, and I just wanted to bring that to your attention. All that we do, I just wanted to highlight some results that they've had. This is all public information. Chinese saccharin, you can see there that the case was 2007, 2012. They finally came out last year because things go through courts. It takes a long time. But that importer was saying that, the saccharin was coming from somewhere else. And it wasn't that, so that they were avoiding the dumping duties. So we found that. We worked with ICE on that, and Immigration and Customs Enforcement that also does fraud, as opposed, among other things. You can see that misbranded drugs coming into the country. We have a lot of big issues with individual packages coming in through mill facilities and express hubs and all that. We work in coordination with FDA on that. And just, I thought it was funny to add this one. Even if you misdescribe something, we find it. One of the ports found, JFK found prohibited meat products that was manifested as pants and other items in clothing. So, they do a lot and they find a lot. And like I said, I'm going to try to help you comply and avoid these situations. One of the other big things, and if you're FDA, especially with fruits and vegetables, there's a lot of crossover with agriculture. And a lot of, you can see the numbers down there. These agriculture inspectors very vigilant. They find a lot of pests on fruits and vegetables, and it could lead to fumigations and things like that, delays of your product. So you have to pay heed to your manufacturers and make sure they clean their products of insects. And I know it's hard; the insects can fly on anywhere, but that's one of the big things that importers run into at the border, because it used to be they inspected every fruit and vegetable that because of the risk of all these pests coming in and ruining our agriculture. They have a more compliance risk assessment effort now, but that's pretty good. Okay, let's get to CBP and PGAs. Like I said, we have a one government approach. You can go to this part of the regulations, and what it does is it tells what CBP enforces for the other agencies. There's a whole host of EPAs in there, some of their regs, FDA regs are in there, NHTSA is in there, National Highway Safety Traffic Administration, and APHIS is in there. So that part of the regs will tell you how CBP enforces those rules. And it sets out remedies when a PGA, we call them partner government agencies, PGAs, the other agencies. So some of the remedies that we basically do for them is, if you're in proper release, if the other agency says don't release it, but it gets released, we can assess liquidated damages and require bonding. And I'll get into more specifics with FDA on that in the next few slides. But anyway, one of the things I wanted to mention here too is there's 15 other PGAs that require data along with CBP entry data. In other words, when goods come in, it used to be that the CBP officer would see a piece of paper and be the one responsible for enforcing the other government agencies' regulations. But with ACE, which I'm going to talk about in the next slide, the PGA actually have access to their own data now when it comes across the border. So we'll get into that. So ACE, there's two sides to it, of course. There's the PGA side, and then there's the importer side. So the first column is the PGA side, of course. And each PGA has its own message set. It requires the importer or broker to submit certain data elements along with the customs entry. It also allows for importers to submit forms that might be required through an imaging system. As I already mentioned, the 15 required data, 47 have visibility. And then I put in the last bullet because sometimes there's confusion. An importer or broker might get a release from CBP, but the partner government agency hasn't released it. So what that means, it's conditionally released, and you have to follow the instructions of the partner government agency. And so that, again, it gives the other government agencies a lot more visibility into what's coming into the country to act. Now, for the importers, they have an ACE portal, and I recommend that any importers actually sign up for these ACE portals. You can click on that link. I don't know if you can click on it, but that's the link up ahead for you to learn everything about ACE. This ACE portal allows the importer, I'll go down one by one on them. If you're familiar with it, when CBP finds violations or suspects violations, they send out requests for information, which are CBP Form 28. If they decided to take an action, they send out a form to the importer or broker called CBP 29. And if there's an unauthorized release, there's a 4647. So all that can be done through ACE now. You can file protests through ACE. If you disagree with an assessment, you can file a protest. One of its good functionality is run reports. So you can go in and see all your imports that come into the country. A few times in my career, I've seen nefarious importers steal other people's importer numbers and use that importer number on an entry. In the old days, the importer would never know that, but now they have the capability to run reports. They might see an entry in there that isn't there. So it's a very valuable tool for importers. You can submit supporting documents. You can submit create a blanket declaration. In other words, if another agency requires you declare that something's free and clear or whatever, you don't have to do it every time. You can just submit it once, and it's always there, so it saves you that time. And then, of course, it's export data, truck manifest data comes through there now. And the bottom one is the managed account and periodic statement data. That has to do with importers who sign up for it and pay all their duties once a month and things like that. So they can maintain all that there. All right, let's get into FDA. Like I said, those are the three things that we can do for partner government agencies, but in particular, specifically with FDA, there's a lot. We do that. They're the agency that CBP probably has the most redeliveries for, and you'll see in the next slide how that Part 12 actually talks about the cosmetic, the Food Drug Safety Cosmetic Act, how we enforce that. As I mentioned before, you might get a release from CBP, but not the PGA. Another part of our regulations, and of course FDA's own regulations, they have a lot more broader detention rules. In other words, CBP, if they don't, after 30 days from presentation of examination, if they don't make a ruling on your product, it's deemed excluded. So they have to act within 30 days. But FDA and some of the other partner government agencies can actually extend that detention period. And they usually notify us of that, and we maintain it at the border. So they have a lot more authority as far as detentions. If FDA, for instance, says, hold this customs, we think there's something wrong, we can require a bond 3 times the value of the merchandise before we let that go to the importer's premises, for instance, if FDA wants that to go to the importer's premises. FDA issues a lot of refusals. And my job that I finished my career with, of course, was liaison with FDA. And every week I'd get this big, long list of refusals from FDA. And we'd have to send them out to the ports, and the ports would have to follow up and issue redeliveries. And if you don't redeliver, there's liquidated damages. And those liquidated damages comport with the value of the bond, which is 3 times the value. So that's how we work with FDA mainly, aside from the targeting I talked about at the CTAC and all that to help identify bad products. Okay, import safety. One of the things that you have to look out for is, mislabeling products, species, for instance. One example in the past was people calling catfish grouper, and we found that, and of course, we did that through lab results. Our labs can identify species, but also in those same cases, the FDA, our coordination with FDA, they found contaminants in the fish as well. So there was dual rules violated in that. We enforce foreign certifications. A lot of food products, especially with APHIS, require certifications that the food is authentic and all that. We work a lot with the Fish and Wildlife Service. There's some food products that could be endangered species, so you have to watch out for that. Legally harvested listed. That's big now with National Marine Fisheries. The whole thing about fish and where it's caught and is it illegal, those are big issues right now. So I put this, know your supply chain. It's on another slide as well, because it's very important that, you know where are your products coming from. I put this slide up, forced labor, because recently there was a change in from Congress and legislation. Of course, imports produced by indentured, child labor and forced labor and all that, we can exclude. And really, it's just based on reasonably but not conclusively indicates that the merchandise is in violation of that, and which means we can stop your shipment and do a further investigation. And really, the reality is a lot of times it's based on an importer or an association that was out there in these countries and found that there was, enforced labor, child labor, and they come in, they write, their case, and they provide that to CBP. If it sounds reasonable and credible, CBP will actually take that action to start an informal investigation. It used to be under forced labor that it could only be enforced if there was a product being made in the United States. That was the law. But since a lot of stuff isn't made here now, Congress took that out. It used to be, it was called consumptive demand, where unless we couldn't enforce child labor unless the product was being made here. But, so that was removed. And again, know your supply chain, what's going on. All right, let's get to the stuff that I think is most important that, I kind of went through how CBP enforces, what it does. The first thing is, you got to know all the CBP and PGA requirements. 50% of imports, maybe even a little more now, are governed by other government agencies. And in the end, you're responsible. If you have a broker and you're not paying attention to what the broker's doing and the broker makes a mistake, by law, CBP has to go after you, not the broker. I mean, we do have some regulations about brokers who are, found non-compliant a lot, maybe not once, but, several times, and then they're not following their license, and that's a separate action, though. It wouldn't be, it's not like the importer, if there was a misclassification and there was a penalty and duties assessed, it would be the importer's responsibility, not the broker's. So you have to be aware the broker has to be aware about your product. Particularly when you talk about FDA. FDA has a lot of program codes, and I knew from working with brokers that it's hard for them to know which program code applies to the FDA sometimes. I think I even looked once and said, I know why they have a hard time. But so you got to know that your broker knows the FDA program codes. If you have trouble with trying to find the right broker, that the resources, the NCBFAA, which is the Broker Association, can help you with that. But we found that a lot. The broker didn't know, but the importer got tagged for the penalty. So, as I mentioned before, a lot of you have ACE now, so there's a lot. The system actually has what's it called, edits that actually check the fields, and if there's something goes awry or doesn't look right, it gets sent to the PGA for review. FDA had that before, I guess, under the old automated commercial system, the mainframe system, but all the other PGAs have that now. The other thing is your manifest descriptions on the bills of lading. If it's kind of ambiguous, too broad, the CB officers are going to, maybe look at that a little closer. So that's you want to avoid. Tariff numbers, you know, you have to know your tariff numbers. If it doesn't match the description, that'll flag it. One of the things we found a lot, and I said I made an example of hardwood flooring. There's a lot of nuances to hardwood flooring, for instance, and the type of flooring, and it could be, for instance, difference of duty of 2% by classifying it under that one HTS number as opposed to the other. We did find, when we got an allegation, we looked at it, and I think out of the 10 importers we looked at, 9 of them were misclassifying it into that lower classification, even for 2%. So the broker has to be careful they choose the right one there. I'm highlighting false organic claims because when I left in January, Congress had passed a law where the Agricultural Marketing Service had to work with us to start enforcing organic claims. And I know it's going through the process now with regulations and all that, how we'll do that. But the issue was a lot of importers claim that their products are organic, and they're really not. And you know, you have to have a certification from USDA that says it's organic and all that. So that's a big issue now with foodstuffs and things like that. Now, the next couple of bullets, CBP does it. Even though we do a lot of enforcement, we actually try to help importers in complying with the law. We do a lot in that respect. So the next couple of slides will talk about that. But CBP has a lot of compliance documents. Under the MOD Act, which was 1993, it's not so modern right now, but it placed the onus on the importer and reasonable care on the importer to comply with CBP's laws. But CBP was required to inform the importers about what the laws were. So they've issued all these compliance documents. They're very good. Anything that CBP enforces, our Office of Ruling Regulations puts out these compliance documents. We have a system called CROSS, Customs Ruling Online Search System. Anytime an importer requests a ruling, that gets the final determination and response from CBP gets posted on the website. So that means if you want to import and you want to know about something, or you have an issue that you're not sure of, you can go to CROSS and put in the word search and see if somebody else had the same issue, and that'll help. And you can read it, and then you can comply with the law because you know it. They put it out there. So a lot of these things, if you do have a violation, some of the mitigation that CBP uses is, you know, did you look here first before you imported? You know, like I said, the importer has to show reasonable care. So it behooves you to check before you import, or if you're still importing, to look at these things about your imports, make sure you are complying. And then we have a lot of account management, which I'll get into. CTPAT, I don't know, you know, you may be familiar with that. It came out of 9/11 to ensure that containers coming in didn't have any explosives and things like that. But it's transformed a bit. It's even used by FDA now in their compliance. They want importers to comply with CBP's Container Security Initiative. And of course, what they do, CBP, is they'll go out and they have to have access to your manufacturer. They go check their facility, make sure it's secure, things like that. They'll check your supply chain. And once we're satisfied that you have processes in place and you become a CTPAT member, you get all these benefits, reduced exams, exemption from our compliance measurement, stratified exams, where the system just generates exams. You might be removed from that. And that really works. I mean, I'll give you, when I worked in the Office of Trade, a lot of the CBP officers, you know, we want to look at something, they say, well, that's CTPAT. You know, we can't look at it, but it's not true. I mean, you can look at it, but what I'm saying is that CTPAT provides those benefits, and if you have CTPAT and you do processing across the southern land border or the Canadian land border, you can also apply for these fast lanes. Again, CBP is looking at your, at that point, they're looking at your driver and your trucks and all that stuff. But they have fast lines at the border for importers that can satisfy the requirements for that. And it's all on cbp.gov. The other thing, which I mentioned before, these Cs. It used to be that before these centers of excellence, every port acted on their own as far as enforcing the laws. Or when I mentioned CBP Form 28s before, you might get 10, 15 different, maybe not that many, but you might go to different ports and get those. Each port would send you one of these forms, the CBP 28. But now they've coordinated all that. All the expertise in the field, it's virtual, but it's centered at each of these 10 Cs now. So if there's a violation or an issue, it all gets up to these Cs, and they handle it. So you only get one. You're only dealing with one person. They also are a good source of account management, which means CBP will treat you as an account. And these Cs, if you contact them, you have the account managers, and they can help you if you have any questions about your imports and things like that. So I recommend you, if you don't already have these, that you take a look at these at cbp.gov. The importer self-assessment program, it's a little harder to get into, but if you really open your books to CBP, they have this program it's about revenue, basically, where you get a lot of benefits. You get, if you find, for instance, if you find that you're making a mistake on your imports and you notify CBP, there'll be no penalties because you found the mistake. And you can file prior disclosure, which is a whole other issue. But that allows you, if you find a violation, if you're not on the ISA program and CBP had discovered it before and you file prior disclosure, the prior disclosure might not work. But in the ISA program, if you find the violation, we'll automatically not assess penalties on that. But that's another program that, for customs revenue purposes, not necessarily PGAs in that respect. So I think that's my last slide. So if you have any questions, I guess you submit them and we'll answer them.
Okay, this is Angel Suarez, also independent consultant with EAS. And thank you, Bill, for the presentation. A lot of the information he provided is a good segue to what I'm going to talk regarding to FDA import arena and how we process all the paperwork out to ACE. So basically, I just put these three definitions in here because depending on who you talk to, what agency, what part of FDA you talk, you have a food safety, which is normally talked in general with FDA. The food defense is strictly, it's the general definition for the Division of Food Defense targeting. And then we have food security, and this is also a lot used with other PGAs, like Bill said. This is mostly when you have issues coming to the United States, like you have a disaster or something like that. That's why we're looking at food security area. But this definitions varies, and I just want to let you know specific about how some of these things match each other. And our intention is that all of us are considered this to determine the degree of situational risk into each criteria to measure the need to implement mitigate any risk itself. This bar chart in here, it demonstrates the last increase of imports for the last 12 years. Really, the last year, 2018, we have over 60 million line relates to food product requiring prior notice, and an increase into 5 to 10% per year in the last decade. So it keeps increasing every year, depending on the economics. Will say that next year this bar could be a little bit higher again and increase to 5 to 10%. Import, FDA regulates a lot of the commodities in the arena, especially in the imports. Devices, it has comprised 48% of all imports, followed by the human food, which is 31%. And that 31% is the 60 million lines of product requiring, including prior notice. And then you follow up with the houseware, food-related items, cosmetics, and drugs, which are the smaller numbers of imported trade commodities. When FISMA came on board, it gave unprecedented authority to the import arena. And these are the import accountability, which is the first time that importers have to have explicit responsibility to verify that their foreign supply have adequate preventive controls. And it's something like Bill said, yeah, you have to know your source previously. Then third-party certification was established a program. We have a certification of high-risk food, which is FDA has the authority to require that high-risk imported food be accompanied by a credible third-party certification or assurance of compliance. Then we have the voluntary qualifying importing program, which is voluntary for importers, provide expedite, review, and entry of food for participating importers. And eligibility is limited to, among other things, into this area. Then we increase, we have a change in there. We have the authority to deny, and that's FDA can refuse the entry of any food product from a foreign facility if FDA is denied access to the facility or the country when there are inspections. I didn't have that line in there, but that's another one. And particular, there's an import alert for that when it happens. Expanded administrative detention, they expanded that part of that was not clear, and they gave more flexibility for administratively detaining products that are potentially in violation of FDA law. And it's really an administrative detention procedure to keep suspect food from move up. Then the last one is the suspension of registration. Before, when they developed the Biotourism Act, it was not very clear. But now is that suspension of registration is FDA can suspend a facility registration when it's reasonable probability of serious adverse health consequences or death, which in other language in FDA is called by SACODA. That area, it was an improvement into the regulations. Now I'm going to go to the next slide, which I'm going to talk a little bit about the different offices. These two offices, the Division of Food Defense Targeting, formerly known as prior notice, and a lot of people keep calling prior notice, even that this is like the 15th year they changed their name. And then they have the Division of Import Operations, which are both are located in the headquarters area. And like you can see these different bullets in here, each one have a unique mission in what is the responsibility of what they have to do. In particular, the Prior Notice Center, it's located here in the Washington, D.C. area, and they are the ones responsible to receive all the intelligence. They are in coordination with CBP and other agencies to do their work, particularly anything related to bioterrorism. However, they turn into the imports operation or DIO. That's mostly the headquarters. They are the focal point and headquarters in the field. They do the policies on imports, procedures, and program, and they are the ones who are responsible for issuing the bulletins and the import alerts. And these are the ones that the field provides the information to them, and then they posted that, and they are the ones who post that. The FDT do not issue imports alerts or bulletins. We work together, but we don't issue any imports. When I say import, the FDT, I was a former of the FDT. That was my last job. Now, with the change of program alignment, and you can see in this map, we have 5 divisions of imports. These are the arms of the FDA. These are the field guys who are there at the ports of entry, U.S. mail facilities, checking. So basically, each one, you can see each division have a group of states that are responsible with their own director, and they have to follow the same norms as all of us. But these are the arms and legs of the import arena. These are the individuals who normally are the ones who go into the field and send you notification about notice of sampling, notice of detention, any release. These are the ones who normally handle all that type of documentation and paperwork. Going to this, it's our DFDT and import program divisions. This is DIO and the field. We have the same goals in here. We try to deploy better our resources. We keep intercepting contaminated products. And it's interesting because many times when an entry comes from the border side and is misdeclared, the field divisions notify DFDT, and they probably find that there's no prior notice in there. So these are the group that we all communicate. And with today's computers and systems, we receive, DFDT receive the information necessary to target or look more in depth to any prior notice. As Bill said, when we have the system, it came to ACE, one government agency. FDA was one of the first one, and we have our own requirements on ACE. And we worked together, and we had to be online when ACE came together because that was one of my main goals of FDA. The filer, the importer files that electronically to ACE. Then it comes to FDA is the system, and this is when it gets the system have criteria in there and targeting where anything that is food, it goes through the prior notice and requires that the Division of Food Defense Targeting review under 801M or 801L. And other regulated products, these are the drug, cosmetics, devices, biologics. This goes divided to the FDA field imports divisions, and they are reviewed under admissibility. That is when a lot of people don't understand, and sometimes they used to call the FDT saying that their product was detained, and it really was a food, and was really a field operation, or it was a food product, but not related to a DFDT activity. And I'm going to explain a little bit more later on here. So let's go a little bit about DFDT. Their mission is these 2 captions in there. They are looking into terrorists, possible terrorist attacks into the food supply in the United States. And also they are looking at the potential contamination of any agent, including biological, chemical, or radiological agents from entering the United States. That's the primary goal or mission of the FDT. They draw this from the section of the 2002 Biotourism Act, and it's section 305, the food facility registration, which is required at the beginning when this was developed, people used to register, and we used to have, they used to have double, quadruple types of registration from the same firm, because each broker, each individual wanted to have the exclusivity of registration that facility for the regional aspect, when it's really one required facility registration. So that changed also in the FISMA when it changed to only biennial registration and have specific requirements to in particular the U.S. agent in that area. Then the prior notice of import, regardless of any size or monetary value, the prior notice needs to be filed. Now, there are some exemptions, and I'm not going to go specific for all exemptions, but there are some of their home goods. Your grandmother or family member and send it to a family member in the United States, that could be one exemption, but you have to go through the different iterations to define that. Also, the foreign governments now under the Vienna Act, they are excluded, and meat products are excluded from the prior notice filing. So I'm going to put in this slide here, basically what happened when you submit a prior notice for the review process on food. 80% of the prior notice comes from the ACE system. Now, FDA also had to provide in another alternate way was the prior notice system interface. That's 20%. That's when that system itself, people, if you don't want to use a broker or importer, you can file that and use that system. And it's online, it's free, and no charges about that. The other one, ACE, is mostly is when you pay your broker. Then it goes to the OASIS PN targeting in OASIS. The system goes to the PN review, and if it's not problem, then it's satisfactory target, and it goes to the 801 admissibility review process. So all food has to go to this step in order to go to the admissibility section. Now, there are criteria in the prior notice system unique to themselves, and that's when you have a targeting hit, and that criteria is set up by the FTT folks, and they can change that criteria depending on the situation. The FTT review, research, if they don't have no threat, then it's PN satisfy and goes to admissibility. If they see a prior notice violation and enforcement acted, they contact the CBP to say, do not move this commodity or this shipment. The file broker is contacted, and then once it's in compliance, then it's PN satisfy and goes to admissibility. Now, when the FTT go back to the center and the review research vetting, then is a possible threat identified. The DFDT have levels of consultation between the director, CBP, other offices. So there's a group of people that discuss and have meetings regard to this particular possible threat. These are received through the information received through multiple sources in the intelligence side. So DFDT really receive that information from multiple sources, including CBP personnel that provides that information. Then if a possible threat is identified, it's a BTA hold. The BTA hold is enacted, and then CBP holds that for examination. The field personnel goes for the sample collection and then laboratory. This is when it takes, when it goes through this process, the hold, it's a longer process because some of the testing analysis takes up to 30 days to receive the final result. If there's a threat in the situation, then there's a cargo disposition. That means is the importer will not receive that cargo. Then it comes between CBP and FDA to the appropriate disposition. And also, most likely, EPA might get involved because there are some issues about how to dispose certain cargoes. There's no threat. It goes to satisfy and then admissibility. Prior notice refusals, a lot of people said refusals in the world, and it really is, it's an enforcement type, administrative enforcement that they start. One of them is no prior notice received. The other part is manufacturer not registered with FDA and submitted of false and inaccurate information. Then it comes to physical review, and from there they may contact the broker, importer, filer, and to ask for additional information in order to mitigate or fix these inaccurate findings. As you can see in this slide, most of the ones on the left-hand side, inaccurate prior notice, are the three I just mentioned in there, including the foreign facility under 801 or no confirmation. The one on the right-hand side, it's the numbers of enforcement actions or holds, and normally DFDT talks about holds into their language and daily work performance. So last year they had over 695 cases in total, and these have dropped, I think, more into the years of the industry learning more about trying to be in compliance on filing prior notices. There are other cases in there, but these are the cases that they happened in 2018. The compliance strategy on the FDT is mostly education compliance goals. This is mostly a call to advise the broker, importer, or the person filing the dependency that they have certain issues in their prior notice and they want to overcome the violation. So they try to inform them and do some compliance on how to do this in an educational way. Then there are informal compliance goals. These are mostly more into being in the registry, because the informal compliance goals are registered into the system in a matter to keep monitoring the individual to see if there are further activities that they need to, they are not compliant, and it's the same issue, not paying attention. Several years ago, they have an action, a compliance action, regarding to a particular firm that they continue not compliant with the information, and they took a compliance action. And this is a very manual, long, extensive process, and it's all based on documentation of a trail of documents that they maintain in their system. The consequences are listed in here, normally in these sections for DFDT when they take actions. And these are, you can read them in the sections of the regulations itself, because many of these have unique criteria and information that requires for the importer, broker, or the person to follow, because like, for example, the FDT will not release anything or go to another location until everything is satisfied. When I said before, when you have a BTA hold, normally the FDT will not even contact the broker for the information or the party involved in here. This is internal communication. So this section here, although there's not directly in the FDT's under the prior notice regulations, or it's something that came aboard in the FISMA. It is because everything that they handle is classified. They will not tell you what it is. So if you, as a broker or a party interested in calling what's going on, I have my goods at the port, you're not moving it, they normally will reply to you and say it's under review. And really the review process is what I said before, is that there's a potential for a BTA hold. They're looking into the situation. They're looking at to physical examination laboratory before they even release that information. And you will never receive anything back from them except for it's a review process. Now, the import division, which is another area I work, and you can see on the right side, everything in blue was what I talked before. Everything that comes to the FDA comes through the system of ACE. If it's disclaimed, it goes back to Commerce. If FDA received, then it goes to what is called OASIS and PREDICT. That's their system, the system into FDA they use to make decisions in there and or target a particular area, whether they have to put an FDA hold or they have to make proceed. We go to the FDA hold, the review, they may request documents. They could do a recommendation of detention. They will review, examine for labeling, verification, sampling, and then it goes to a compliance officer. The compliance officer, based on the results of the laboratory analysis, could release it, and then it could be one area that goes back to Commerce. However, it is incumbent of the importer, if it's a violation, it will be, they have to correct that information. That could be a mislabeling, adulteration. If it's filth, for example, insects, there's a process for that, but not all detained product could be easily corrected. Then if it fails to overcome the appearance, it refuses, and then once we refuse it, it goes to CBP with information of 90 days to be exported, or the importer could have the option for destruction. This is something like Bill was saying before, they have 30 days, but then we have a process we can expand a little bit more into the process of extending this more than the 30 days that CBP have received of the paperwork. They are refused entries on their way one because of alteration, misbranded, they're forbidden or restricted for sale, or may not comply with the United States requirement refusal mission. This is when the FDA refuse products and they need to be destroyed or exported within the 90 days. And there is a particular section on the Act 801E, which have several areas in there, several paragraphs to be correct, where the importer has to follow. And one of the most difficult one is if you have moved your goods and decided to start selling before the release, if you cannot satisfy the redelivery, and then you'll be in a little bit more trouble. Because then the FDA compliance could take an action and not allow you to export the product, and you may end destroying the product. But this is discretionary into the compliance officer, depending on the situation. Not all cases, most of the time, my experience was to be destroyed in the past. And now there's some leverage that they were allowed to export. And each situation is unique. There are always FDA is looking for, this data is for the 2018. They have not published anything on the area of 19, although the fiscal year ended this it will end shortly in the data running. It was September 30th. They still running the data. But there are areas of common entry errors like the compliance, failure to put the product code, quantity, shipment, value, consignee. These are category errors that are found through the process of receiving information through the ACE system. And this is mostly handled through what the field divisions look into normally when they do import entry review. Like I said, the FDT have other qualifiers, and that data is not included in this particular pie chart here because they don't publish that type of information. Okay, you can see this red list, green list, and yellow list. This is mostly what is an import alert and how FDA categorized the import alerts. Your red list is where you don't want to be. That's when you have the detention without physical examination. This is made on recommendations from the field. They found, for example, pesticide, that residue is too high, there's no tolerance. It could be that particular area. The other red could be in the list. It could be that you refuse the inspection. Or under FISMA, the FSBP for supply verification process, which is recently a new import alert they have just this past summer, it could be on the red list. The green list is different. They meet the criteria. And there's no, there's unique because it could be for a particular firm, products, and country that met that criteria. So not everybody is on the green list. It's not a blanket itself. And the yellow list is more intensified surveillance. And these are require more surveillance and field examination by the field personnel. Each import alert describes it's a guidance to the field. And I encourage everybody who is importing to look at the import alerts in FDA. They are public, there are information in there about it. And you can search in the FDA import arena website about whether your particular firm or the firm you're interested in is on the red list itself there, and what are the reasons or the cause for that red list to be particular. You have also firms that fail to do the seafood hazard or the use hazard. Those are specific. Each importer have a number related to the specific guidance. The field look into this very closely. And if they feel strongly that the firm needs to be an importer, they will submit that to the Division of Import Operation headquarters in Maryland, and they will look into adding that under the importer. And these are, I would say, very, daily updated list. If you have you want to be removed, there's another process for FDA. And this requires, depending on the particular situation, that you have to satisfy and provide to FDA the information necessary to overcome the violations. Previously, like I said, and Bill said, your supplier here is import accountability or supply and verification. They need to, they have certain requirements in the direct custom movements, certain requirements of manufacturing practice regulations, and all this part, what I'm trying to demonstrate here is mostly the dietary supplement, because they're looking more into this particular area in the foreign supply verification program. So if you are in that field, look into that part, this part of the regulations. Refusal of admission is subject to when you have a problem with Section 801A3, which is the food failed to comply. Basically, this is what the authority that the FDA have under FISMA on the consequences of failing to comply with the requirements under FISMA. So, in the import supply responsibility it's the first time that it's first major compliance for importers to verify that the foreign supplier it's meeting the applicable FDA standards. It's also looking into the importers that FDA regulated, ensuring that imports are compliant with FDA laws and regulations. And like Bill said, before shipping, you should be aware and know who is your supplier. For those who are interested, and if you have run into a problem of DFDT violations of concern, here are the telephone numbers for the DFDT in the U.S. is a toll-free number. However, international, the 571, which is the second number, they only operate for that is a different office, not within DFDT. That is controlled by the Center for Food Applied Nutrition. And then that group only works from 7 to 11 o'clock. So the other alternative way is to contact them either by email, and the FDT will answer you that email or the question, or it might refer you to the proper office that may need to answer you your questions, because yes, they receive questions from admissibility and they have to refer this to the proper office for handling the answer. The FDT will not answer questions regarding to admissibility under 801A. If you want to be removed, then from any importer, there's a petition process, and you have to send that request to via email or write the Division of Import Operations in Brockton. There is more information you can find in the last bullet about what you need to know about requesting to be removed from the importer. If you receive a notice of FDA action, notice of sampling, release notice, or detention hearing, or notice of refusal admission, like I said at the beginning, is these deviations the compliance officers are responsible for handling. So just because you may receive sometimes a message that the compliance officer may not, may be on leave or out of the area, don't get discouraged. There is the system, each division have their own email, and they can, other alternate compliance officers could handle your case, or they could put in their message who is handling the case in their absence to various reasons. So each division is responsible to handle their territory grounds. I would say that in my the discussions in the past with FDA, it could be that the Division Northeast compliance office could be out, and somebody else in the northern border could handle that compliance goal or answer there. But normally, because they can see everything in the system, they have the system itself. Now that FDA is more. So if you are trying to, in the past we used to call port shopping, if you file through the A system, now FDA in general could see where it was filed, where it's going. And if you attempt to bypass the system, any of those divisions will see information from that, and that's in this internal system of FDA. That's all for my presentation. So if you have any questions, we're open now for the questions.
Great, thank you so much. I appreciate that presentation for both of you. For those still in the audience, now we ran a little long. I just want to mention we have a couple additional webinars coming up that might be of interest. On November 6th, there is a webinar on how to become a sought-after expert witness. And the following day, November 7th, there is a webinar on dietary supplement GMPs and a look at FDA enforcement actions. Have one question in the audience, and that is regarding how do you make an assessment of your suppliers? And Bill or Angel, I'll let either of you take that, and then we will wrap it up. And thank you again for joining us if you aren't able to stay through the Q&A.
Yeah, I mean, yeah, actually, you know, there was one court case where the judge said, you know, did you ever go visit your supplier? To check their facility. you know, CBP has a lot of literature online too of how they evaluate manufacturers and all that. So that we're a good source as well by contacting them. But you know, the onus is on you to verify that they comply with that. You know, it has a lot to do with you know, the employees at the facility, things like that, fencing around the facility, and things like that. So what I recommend is you go onto our CTPAT website, and I think they have actual lists of how there's compliance. But that's basically what you got to do is visit them and see if they comply with security standards.
Right, good diligence. I'll also mention EAS, of course, is able to help with evaluation of supplier assistance. We act as a U.S. agent. Our company with qualified individual requirements for food importers. So we have, of course, two great experts in front of you in this webinar today, and a number of other services that we provide in the field. If you have any assistance, of course, please let us know. And Bill and Anhel, thank you so much again for your presentation today. And we hope to see you again at a future webinar in the future. Thank you.
Thank you.